Welcome everybody to the Federal Tribal Relations panel. Just some housekeeping details about CLE to get us started. CLE credits are going to be available for this panel in the following states: Arizona, California, Colorado, Illinois, Iowa, Maine, Michigan, Minnesota, Pennsylvania, Washington, and of course, Wisconsin. For those of you who are attending virtually, there are going to be secret words administered by me throughout the presentation, which will be used to verify your attendance at this panel for CLE purposes. You must indicate those secret words on the CLE handout provided to you by email before this event. Please pay attention to those words as they're necessary for you to receive CLE credits for your attendance. For those of you who are attending in person, please track the minutes you spend at this panel and indicate the amount on the CLE form available on the Wisconsin Law Review Symposium webpage. There are also background materials that accompany this panel's presentations. Please visit the Wisconsin Law Review Symposium webpage to download them. There are also QR codes posted at the registration table and around the room, which will connect your device to the webpage. At the end of the presentations, there will be a short Q&A. If you have questions and are attending virtually, we ask that you provide that question in the chat, and we'll preserve the question until the end of the presentations. If you're in person and have a question, please raise your hand, and one of our volunteers with a microphone will go to you and hand you the microphone for your questions. We'll alternate between in-person questions and those submitted online. Please note that we're going to try to get to all of your questions, but because of the time limits, that may not be possible. Finally, I'd like to remind everyone that masks must be worn at all times during the presentations, the Q&A session, and while you're present in the law school building. At this time, I am privileged to introduce our panelists, each of whom has an incredibly distinguished career in public service. The panelists will be speaking about the sources of federal and tribal power and the relationship to each other. First off, Ambassador Keith M. Harper is a partner at Jenner & Block, where he chairs the Native American practice, and he's also co-chair of the Human Rights and Global Strategies practice. From 2014 to 2017, he served as U.S. Ambassador and permanent representative to the UN Human Rights Council in Geneva, Switzerland. Ambassador Harper served as class counsel, representing a class of 500,000 individual Indians in Cobell versus Salazar, involving the mismanagement of trust funds by the Department of Interior. And he was successful in ultimately settling the case for $3.4 billion in 2009. He is a citizen of the Cherokee Nation. Diane Wood is a circuit judge of the United States Court of Appeals for the Seventh Circuit and a senior lecturer at the University of Chicago Law School. Judge Wood attended the University of Texas at Austin, earning her BA in 1971 and her JD in 1975. After law school, Judge Wood clerked for Justice Harry Blackmun of the United States Supreme Court. She was the chief judge of the Seventh Circuit from October 1, 2013 until July 4, 2020. She also chairs the American Academy of Arts and Sciences Council and is on the Council of the American Law Institute. And our third panelist is Mr. Edwin Negler, Deputy U.S. Solicitor General, a position he has held since 1993. After graduating from the University of Virginia School of Law, Mr. Kneedler clerked for Judge James R. Browning of the United States Court of Appeals for the Ninth Circuit. Before his tenure as Deputy Solicitor General, he served in the Office of Legal Counsel at the Department of Justice. Mr. Kneedler became acting Solicitor General in 2009, a capacity in which he served until Elena Kagan's confirmation later that year. As of June 2020, Mr. Kneedler has argued more cases before the U.S. Supreme Court than any other advocate. It's my pleasure to welcome each of you here to the University of Wisconsin Law School and the Law Review Symposium event. We'll hear from each panelist in the order in which I introduced them. So with that in mind, please join me in welcoming Ambassador Harper to the virtual podium.
Well, thank you, Professor Schwartz, and thank you to the Wisconsin Law Review for inviting me here. And I'm honored to be on this panel with two extraordinarily distinguished co-panelists. I thought that I would divide my remarks into to three areas. First, of course, when you're thinking of federal-state, federal-tribal relations, that brings up the issue of what is, in fact, Congress's power regarding Indian affairs. So I'll begin there. I'm also going to touch upon another aspect of federal tribal relations, and that is when the United States holds property on behalf of individual Indians or tribes for their benefit, and when it breaches trust duties regarding those. And finally, just briefly, I want to touch upon the nature of the federal tribal relationship today, and especially the sort of evolution of tribes as they have been self-empowered over the last few decades. Sorry, I'm trying to. So we should start off on the issue of congressional authority by recognizing that there is a consistent and constant effort by opponents of tribes to question what has long been termed by the Supreme Court and other courts as the plenary authority or the plenary power of Congress over Indian affairs. Let us first acknowledge that the U.S. Constitution does not, in express terms, grant Congress plenary authority in Indian affairs. This is, of course, distinct from other clauses, such as, for example, the District Clause, which basically provides that Congress has what's called exclusive legislation in all cases whatsoever over the district. But the Supreme Court has long established that the powers of Congress over Indian affairs is, in fact, plenary and exclusive. There have been numerous different explanations for the basis of these powers. It seems to me that the most recent discussion by the court of congressional authority, at least extensive coverage of congressional authority in United States versus Lara, is probably the best articulation. There are, of course, other authorities that tie the power to some combination of the Indian Commerce Clause and the treaty powers. But Lara, I think, is fair in its articulation because it recognizes both the express places in the Constitution where Congress has authority, but also the implicit places that are not enumerated specifically in the Constitution. Lara says, for example, Congress's legislative authority would rest in part not upon affirmative grants of the Constitution, but upon the Constitution's adoption of pre-constitutional powers necessarily inherent in any federal government, namely powers that the court has described as necessary concomitants to nationality. And it cites the seminal Curtis Wright case from 1936, which addressed federal powers in foreign affairs, and ties the powers of Indian affairs to pre-constitutional powers exercised by the sovereign and not necessarily exercised by states. This formulation to me is a far better formulation because it avoids the question of whether or not there has to be an enumeration and what are the limits of that enumeration. Because what that does is essentially breed litigation as parties quibble over what exactly the Indian Commerce Clause means or doesn't mean. And it's clear that like foreign governments and like foreign affairs, tribes have always been dealt with on the federal level. So quibbling over whether or not the enumerated powers are sufficient in a given case seems to ignore that. Over the many years, there has been numerous challenges And still today, there are numerous challenges as to whether or not Congress's power can enact various pro-tribal legislation. As tribes have increasingly gained authority and increasingly been politically active, they have been able to achieve momentous legislation, things like the Indian Child Welfare Act, the Indian Gaming Regulatory Act, the Indian Self-Determination and Education Assistance Act, the Indian Minerals Development Act. And of course, during the Obama administration, there was the Violence Against Women Act reauthorization, which for the first time provided jurisdiction criminally over criminal defendants in certain qualifying crimes, even if they were non-Indian. And so this is, with this empowerment, with this watershed set of legislation, opponents of tribes are trying to limit and argue for limitations over tribal powers, over congressional powers over tribal affairs, and have tried to chip away at the plenary power doctrine. This is occurring presently in a case called Brackeen. Brackeen deals with the Indian Child Welfare Act that I recently mentioned. It's a challenge by a set of families in the state of Texas, arguing that the Indian Child Welfare Act is unconstitutional on a number of grounds. Most prominently, they argue that it violates equal protection, which I'll discuss in a moment. They also argue that it is a violation of what's called the anti-commandeering doctrine. They also argue that Congress has no authority to enact this law, particularly because it's not on or near an Indian reservation. In an en banc decision of the Fifth Circuit, there are 320 pages of opinions. 3 provisions were struck down on anti-commandeering grounds. ICWA was largely upheld. Right now, there are 4 cert petitions pending before the Supreme Court, one by the United States, one by 4 intervener tribes, one by the families, the adopting families, and one by the state of Texas and other states. Plaintiffs in the case argue that Congress does not have the authority to enact ICWA. They contend this to the extent that it directs states and states courts to adopt ICWA's preemptive rules. One of the arguments that they make is that the limitations on plenary power are those that one limitation is that it has to be legislation that is at or on or near a reservation. But it's pretty clear that Congress has enacted numerous laws that have an impact beyond reservation boundaries. And another argument is that it violates the Equal Protection Clause, which is related because in essence it's saying that Congress cannot pass laws that benefit Indians because it's a violation of equal protection. And so it's essentially an argument on the limitation of congressional authority. Any analysis of equal protection issues in the context of Indian affairs, of course, must refer back to the seminal case of Morton v. Mancari. The simple rule of decision for Morton is that Congress can treat Indians differently without violating the Constitution, so long as, quote, the special treatment can be tied rationally to the fulfillment of Congress's unique obligations towards the Indians. That's because the special treatment of Indians is rooted in tribal citizenship in Indian tribes, and accordingly is a political rather than the racial distinction that is made clear in Morton. Accordingly, strict scrutiny is not triggered when there is a differentiation between Indians and non-Indians. Nonetheless, equal protection challenges to pro-tribal legislation continues to be asserted with fair regularity. Brackeen is a recent example. Plaintiffs argued there that treating Indians children differently should be scrutinized strictly. They point out that the definition of an Indian child is not limited to citizens or members of a tribe because it allows for those children who have a biological parent who is a citizen and is eligible for citizenship to be included in the Indian child definition. But this seems to me to be a rather weak argument, and that's because, for example, children born by Americans abroad are eligible for citizenship, but have to get it confirmed through a U.S. process. At the time, they're not citizens. And it's self-evident that this does not make it a racial distinction between a child of American and, say, a child of somebody from France, from French citizens, even if both are born in France. Another contention is that Morton is limited to laws that apply on or near the reservation, as mentioned earlier. But Morton doesn't say anything about that limitation. It does talk about other laws that are about on or near the reservation. And indeed, the preference, the employee preference in Morton itself applies in Washington, D.C. at the BIA headquarters, which is nowhere near and certainly not on an Indian reservation. The Fifth Circuit essentially agreed on this point, even though it was hostile to the pro-tribal position in numerous other ways. In an interesting way, I think one of the things we should point out is that these challenges to congressional authority are greater today as a result of tribes having achieved a lot of legislative priorities over the last few decades. Let me turn for a moment to another topic, which is the relationship between the United States and Indian tribes when the United States holds property as trustee on behalf of a tribe or an individual Indian. This is not what is sometimes paternalistically referred to as the guardian-ward relationship or the general trust relationship. What I want to focus on is when there's actually a trust corpus for a specific Indian beneficiary, whether tribal or individual, that is being held by the United States. There are two issues that are heavily litigated in this front that I want to focus on. The first is the nature of the action, and specifically whether or not the action in district court, federal district court, is an action under the Administrative Procedures Act or some independent cause of action. Of course, to sue the United States, you must identify three things: a federal jurisdiction, a waiver of immunity, and a cause of action. These are lands held in trust and governed by federal law, so any related disputes would, of course, arise under federal law, and therefore there's jurisdiction under 1331. With respect to the immunity, the APA provides the immunity waiver, and of course, it's settled law that the APA's waiver is not merely for APA cases, but for non-APA claims, so long as they're not seeking money damages. The cause of action is that it is a right to sue to enforce trust duties in the district court outside of the APA. This issue is commonly litigated because, of course, APA cases limit discovery, or discovery is usually not allowed. It's reviewed under the administrative record. So if this is a normal case, then say you're suing for the enforcement of an accounting requirement or duty, or enforcement of some other duty against the United States, then the question arises whether or not those APA limits apply. And I think the courts have not decided this. They have numerous courts have addressed this, but the Supreme Court has not decided this one way or the other. It is an issue that I think that they will have to address at some point, because it will continue to be litigated because of the implications of having an independent cause of action, as is recognized in the Court of Federal Claims. Of course, there's no express cause of action in law, generally speaking, yet the the Supreme Court recognized that the Court of Federal Claims for money damages suit, so long as the statute is money mandating, does have jurisdiction to hear those suits. The second issue that arises widely, it has to do with whether or not the common law of trust applies to when the United States acts as trustee. And the reason this is important is because the United States often does not live up to that standard. And the U.S. argues, generally speaking, that the common law of trust does not apply. And to be sure, there is case law such as such as Navajo, that suggests that any duty, any requirement must be rooted in statute or treaty. However, it's equally clear that the duties do not have to be expressed in statute. The most important recent case in this regard is White Mountain Apache. That case involved the 1960 Act that placed Fort Apache in trust for the White Mountain Apache tribe. Upon returning Fort Apache to the tribe, it was in gross state of disrepair. The tribe sued for breach of trust. The government argued there was no express duty to preserve the trust property. And on this point, the government was correct. The 1960 Act said not word one about a duty to preserve property. Nevertheless, citing the common law duty to preserve trust property, the Supreme Court held that the U.S. was in fact liable. So, this is going to be another issue that is going to be consistently contested, because to the extent trust duties apply is to the extent that you will have an expanded set of expanded capability of tribes to seek relief for actions that would breach fundamental trust duties. I guess in closing, I just want to say one thing about the federal tribal relationship, and that's this. For many decades, for centuries really, there was policies such as allotment and termination, removal that were grossly hostile to tribes and their citizens. But we should also recognize that since the 1970s, the United States has made an extraordinary turn towards a much more pro-tribal stance in what's been called the era of self-determination. And there's a vast set of laws that have been enacted where tribes have been significantly empowered in all walks of life. Now, this is not to say that there aren't existing challenges. There are many existing challenges, and there is much work to be done in tribal affairs. But I think at times like this, we should also recognize the progress that has been made economically, socially, culturally, politically in Indian country. And that Indian country today is far better off than it was 10 years ago. And 10 years ago was far better off than 10 years prior to that, and so on. For the last 50 years, it's been an upward trajectory. And the federal tribal relations has never been stronger. It was unheard of when I came to Washington in the early 1990s to think of a world in which tribes would have jurisdiction over non-Indians who abused women on the reservation. We have that jurisdiction now. It was inconceivable to me that there would be a Secretary of Interior who would be a Native woman. So these challenges and these legal issues are important. They will continue to be litigated, but we also need to take stock of the fact that we are in a different place today than we have been in the times past. I'll end there. Thank you.
Thank you so much, Ambassador Harper. I'm now going to announce the first secret word for the online CLE participants, and the word is Constitution. Our next speaker is Judge Diane Wood.
Thank you very much. It's really a pleasure to be here, and I have to begin with a disclaimer. Ambassador Harper and Deputy Solicitor General Kneedler are true experts in this area. I am certainly not that. I have written over my career maybe about 11 opinions dealing with Indian law. The Seventh Circuit is not a circuit such as the 8th or 9th or 10th where these cases are frequent, but it's definitely an interest of mine. And in this instance, it intersects with a broader interest in what sovereignty means at a high level. So I thought I would share some thoughts about that with you today. Again, recognizing that the real experts are the other two speakers. All right, so, and the other thing is, I was going to say, the other perspective I can bring to this is, why did the ALI decide to take this up? What was the hope, and what has been the result of this tremendous effort to produce this restatement of the law of American Indians? So we all know that about 200 years ago in the Cherokee Nation case, Chief Justice John Marshall famously described the Indian tribes as domestic dependent nations, quote unquote. It's a catchy phrase, but it falls far short of a clear description of the complex relationship between federal tribes, bands, nations, etc. I'll just call them tribes for simplicity, in the territory encompassed by the United States and also vis-a-vis the United States government. And the phrase also elides the equally complex question of the relationship between Indian tribes and the constituent states of the United States, which I realize will be discussed later. For this panel, we're dealing with federal tribal relations. I think in the end, the problem is that modern notions of self-determination, the very sort of thing that Ambassador Harper was just talking about, don't map particularly well onto the history up until maybe more recent years of our part of the North American continent from the late 15th century to the present. No one could have undertaken the task of tackling this complex area with more sensitivity and expertise and objectivity than the reporters of the American Law Institute's project, Professors Matthew Fletcher and Winona Single and attorney Kane Smith. Ed and I, at least, I can't remember if Ambassador Harper was at this first meeting, but Ed and I definitely were both present at the creation of the project, and it's just been an astounding success. I think this is maybe one of the most challenging restatements that the ALI has ever undertaken, because think of the normal thing. Think of restating torts or contracts, or for that matter, even conflicts of law. There's a body of law, the reporters study it, they try to distill some sort of common rule from it. If there isn't a common rule, they try to see maybe which is the better rule, or which is the predominant rule, or which reflects the trend of thinking. And that's all fine. The challenge for the American Indian Project was quite different. And that becomes apparent immediately when you look at the introduction and realize that instead of just this organically developing body of law, the reporters identify 7 different periods that the law has moved through, from colonial to American treaty, removal, assimilation and allotment, reorganization, termination, and then finally this self-determination place that we seem to be in. And there's a real question whether this is one of those situations where, to borrow Dr. Martin Luther King's phrase, used also by President Obama, whether the arc of the moral universe is bending toward justice. So maybe this last stage of self-determination is the time. Maybe we're finally going to get it right. But trying to come up with this rich body of law with consistent principles was no small task. So I thought we could look at this through the lens of sovereignty, since that really is mostly about the relationship between the federal government and the tribes. And I'll make 2 remarks about sovereignty to start with. One of them is that no one knows what it is. Dean and then Professor Michael Scharf captures this. He has an article that he calls Earned Sovereignty, Juridical Underpinnings. And he begins with 2 quotes. The first is from Stephen Laycock, and it's very short and pithy. Quote, "Sovereignty either is or is not, period," close quote. The second quote he fronts the article with is from former UN Secretary General Boutros Ghali, who wrote, quote, "It is undeniable that the centuries-old doctrine of absolute and exclusive sovereignty no longer stands, and was in fact never so absolute as it was conceived to be in theory." So I would say that the former Secretary General is much closer to the truth. Sovereignty has always been a somewhat messy area, and nowhere more messy than in the United States. You think of Justice Anthony Kennedy's famous statement in the US term limits case, which was about whether states could add to the requirements for membership in the House of Representatives or the Senate. And it's a very long opinion, the majority opinion written by Justice Stevens, but what people have remembered is what Justice Kennedy said in concurrence. He writes that, quote, "Federalism was our nation's own discovery. The framers split the atom of sovereignty," period, close quote. He was talking about federalism, federal state, but you can split an atom in more than two pieces. And it's actually, in some ways, a very evocative statement if you consider the violence that typically attends atom splitting. It's a pretty big thing to do. So let's look at Indian tribes. They certainly do enjoy considerable attributes of sovereignty. And this is, not only is this not new, this was the original situation. The law of nations is what informed early encounters between the tribes who were in the United States area, now covered by the US, is what I mean to say, and the various settlers who came. And treaties were entered into from even before the constitutional time, actually all the way up until 1871, and then those treaties were preserved. And so that's one model. There's the sovereignty model. Then, as we know, you can find statement after statement in opinions from the Supreme Court about, don't know quite how to phrase it without using these terms, but a guardian-ward relationship or a power that has some duty to the tribes to protect them or to have, canons of construction that are protective for treaties or for legislation. So I think those are two significantly conflicting models, and maybe we are gravitating toward the sovereignty model, but let me talk a little bit further about this. I thought it might be interesting to look at the general model internationally of sovereignty and see where the tribes are really in a very strong position and where developments have not maybe reached that point. So again, there's another American Law Institute project. There are a couple of restatements of the law of the foreign relations of the United States. And the relevant one is the third restatement, which was published in 1987 for my purpose. The ALI defines the term state as follows, quote, under international law, state is an entity that has a defined territory and a permanent population under the control of its own government and that engages in or has the capacity to engage in formal relations with other such entities, period, close quote. So I see in that 5 requirements. Is there an entity? Is there territory, permanent population, government, and external affairs? So let's take those one at a time. Certainly there's an entity in Indian law. Section 2 of this new restatement defines and describes the term Indian tribe to include all sorts of other groups. As I said, any Indian or Alaska Native tribe, band, nation, pueblo, village, community that either is recognized or by the Secretary of Interior or Congress has acknowledged to exist. So we have, as you know, probably everybody knows this, 574 recognized tribal entities, and there are others that the restatement acknowledges that are not recognized, but that still have an existence. In fact, one of the cases that I wrote had to do with the Menominee in Wisconsin who had gone through a period of not being recognized and they were re-recognized. So this can be complicated. But I would say check on that point. Yes, there's a defined entity, which is the tribes. Defined territory. I think you can check yes on that too. Now, certainly if you go far enough back in history, the Western European type concept of defined territory was a poor fit for the way the tribes and the other groups who were already here understood their relation to the land. But the restatement defines a term that is pertinent today. Section 3 defines Indian country, and it does so in terms of specific land areas. So land set apart for the benefit of Indians or Indian tribes under federal jurisdiction. And then I won't read them all, but there are a bunch of kinds of lands: reservation lands, allotments, lands held in trust, and so on. Now, the United States can both add to and subtract from those lands, in other words, the federal government. So what are we going to make of that? Now, certainly, if you compare tribes to states, that's a significant difference. States can't make themselves bigger or smaller without the consent of Congress, according to Article 4, Section 3 of the Constitution. So new lands don't come in as states automatically, they come in as territories. Then there's a big process to bring them in under their equal footing. But the restatement indicates, and our history tells us, that the federal government can add to the area of tribes, it can subtract from, and it has in fact done so. Interestingly, there is no requirement that the tribe itself consent. It's just a power of the federal government. Next criterion, permanent population. I think you have that as well. The term Indian is defined in the restatement. It's actually what the whole thing starts with after the introduction, section 1. This can be very complex, but this takes a fairly straightforward approach. An Indian is a member or citizen of a federally recognized tribe, unless there's some other statute that you need to apply. So tribes have retained a tremendous amount of autonomy over this. Usually there's a genealogical or, quote, Indian blood dimension, there's a membership dimension, but it's up to the tribes, basically. And so you would say, well, that looks pretty strong on the sovereignty side of things, too. The next criterion, own government. This is quite complex because of this plenary power that the federal government exercises over tribes. And so there, I would say maybe there is a significant disconnect between the version of sovereignty enjoyed by Indians and that which you would find either in an international actor or even a state of the United States. Tribes undertake their powers subject to restrictions that Congress has given, and what, maybe Congress has given more sometimes and maybe more in recent years. But the fundamental power of Congress is clearly there, and so that's a limitation. Now, of course, this doesn't totally distinguish tribes from states, because even in the original Constitution, it's very clear there are restrictions from the Constitution imposed upon the power of states. Article 1, Section 10. Sets out some very important restrictions. States cannot enter into treaties with foreign powers. They can't coin money. They can't impose import or export duties. They can't maintain troops or ships of war or make war unless actually invaded. And so the people who wrote the Constitution created some significant carve-outs for the state power. And so they too don't have, plenary power, and yet we certainly recognize significant sovereignty in the states. One has only to look at the long line of cases from the Supreme Court about state sovereign immunity. And of course, there are cases about tribal sovereign immunity as well. That has come up in things that I've seen. So it's there, but it's contingent. And tribes are they're not really quite under the supremacy clause either, because they are pre-constitutional entities. They do not get created by the Constitution. The states in some ways are too, but it's enough to say that the self-governance criterion is a complex one. And like the constituent states of the United States, since 1871 at least, tribes have not been entering into treaties with the United States as a whole. Congress decided to substitute legislation for that. And the tribes, like the states, don't enter into separate agreements with foreign powers. The tribes, though, do have more power, as far as I can tell, to enter into intergovernmental agreements at the more local level. States are subject to the Compact Clause, and tribes, I think, are not. So if tribes want to create cooperative areas, they can do that. So, and the other thing to say about the treaties with the United States is, even though there were no new treaties after 1871, that very legislation says all the existing treaties are still in force, and we have only to look at the McGirt against Oklahoma case to realize that that can have a tremendous impact on the outcome of cases. So what do we do with all of this? So we have these very strong statements of sovereignty in the restatement. We also have section 6 on the canons of interpretation that apply to Indian treaties. We have canons of interpretation that are discussed for legislation affecting Indians. And it's all very, one gets the sense of protection looking at these things. So a treaty has to be construed liberally in favor of the signatory tribe or tribes. Genuine ambiguities have to be resolved in favor of the tribes. You've got to look to the understanding the Indians themselves would have had at the time of the negotiations, which can be quite a task if it's an older treaty. And finally, somehow or another, you factor in the surrounding circumstances and history. These are not the canons of construction that would be used for an international treaty that the United States entered into, say, with Mexico or something. For that, most people would agree that one would look to the Vienna Convention on the Law of Treaties. The United States is not a signatory, but on the other hand, the United States has accepted most of the Vienna Convention as being reflective of international law. And it doesn't have a thumb on the scale for either side, even if there was unequal bargaining power, even if there is, some inequity between the two sides. It's just, you interpret the treaties in good faith, you interpret them with the ordinary meaning of terms, things that probably sound pretty familiar if you follow statutory interpretation. You can look at preparatory materials, but it's just a different set of norms than we find, at least in this restatement, for the interpretation of treaties. The courts do cite these canons. I wonder sometimes whether the canons are driving the result or whether they're just being cited in support of a result that the court has decided is the correct one anyway, based on the language of the treaty. So you have these treaties, and you have kind of a corresponding set of canons for legislation. And I will note that the restatement serves up not just this issue, many issues, if you read through the fine print of the restatement, are flagged as moving targets, basically. There is litigation right now in courts that could have an effect on them. One of them has to do with the canons with regard to statutes. You could say that these canons, like the ones for treaties, are going to be protective of the Indian interests, or you could say Chevron and Skidmore deference apply without any particular push one way or the other. Or maybe, like some members of the court, maybe they're going to throw away Chevron and Skidmore. So, who knows, but this is an area that I would just say is in movement now, and the reporters just flag it and they say, we've got to stay tuned. There might be a second restatement if Indian law if too much changes. So let me just flag one or two other areas that I thought were pretty interesting, and then I'll turn the floor over to Ed. One of them is a huge interest of mine, and it's the area of extraterritoriality. To what extent can you look at the territory and realize that this actually is congruent with both legislative and adjudicative power? And Indian tribes are in their own situation with respect to that. The Supreme Court follows a presumption against extraterritorial application of congressional legislation, and it's actually strengthened that presumption, in my view, in recent years. But within the United States proper, nobody worries about whether Congress has the power to legislate and the power to establish courts to adjudicate cases. Much more complex with the Indian tribes, because in some ways they have more power, and in some ways they have less power. So there are limits on tribes' ability to regulate the behavior of non-members, even within Indian country. I know the Violence Against Women Act has now changed that for that field, but there are, it's a very case-by-case basis, I think. Off the reservation, tribes sometimes have surprisingly robust authority to do things that look like civil regulation. I think, as say, for example, Herrera shows, tribes may have the right to engage in off-reservation hunting and fishing and use of fructary activities because the treaty that they entered into with the United States has given them that power. Water and air rights, also common subjects. One of my cases dealt with an upstream thing that the state was going to allow to be built that was going to pollute the water that the Indians relied on. The Indians were able to take action against that. And actually, one of my favorite cases ever, it's a pair of cases, tribes were among the people who were challenging the measures that the US government was taking to protect the Great Lakes from the Asian carp invasion, which isn't over yet by any means, but it was a consortium of states and tribes that were claiming that the US government was not doing enough. This was an unsuccessful claim at that point, but their interest was certainly recognized. So what can you do on or off the reservation, I think is quite interesting. Ambassador Harper mentioned the Mancari case, absolutely an important case, but I think the Supreme Court someday is going to have to grapple with how it intersects, if it intersects, with the Cayetano case from Hawaii, because there, some members of the court felt, you can't have this kind of carve out even for the native groups. Now, I am not going to say anything definitive about this. It's the sort of thing that could come up before a court. I think part of that is at play in the Indian Child Welfare Act litigation that was referred to. So we're going to have to see whether this Supreme Court is comfortable with the idea that Indian tribes are essentially political entities and not therefore subject to some of our, even the rules in the Indian Civil Rights Act about discrimination or denying somebody the equal protection of the laws, not to mention, other constitutional norms. So I think that's an area very much in movement. And lastly, I just think, again, this restatement gets you part of the way, but you have this sovereignty theme and you have this protective theme. And at some point, I think they're going to need to be reconciled one with the other. That said, I think the restatement has really contributed to this field. It is going to be used by people like me who don't know this law as well as you do. And I'm very happy that the ALI undertook it. So thank you very much for inviting me to this.
Thank you very much, Judge Wood. I'm now going to announce the second secret word for online CLE participants, and the word is sovereigns, plural, sovereigns. Our next speaker is Mr. Edwin Negler.
Thank you very much. It's a real pleasure to be here. It was a real honor to participate as a member of the Advisors Committee on the preparation of the restatement, and I want to congratulate the reporter and all those who've worked on it for pulling together, as Judge Wood explained, this very sprawling area of the law, both in present day in terms of its origins. I wanted to start again with the source of federal power over Indians, and then the plenary power, and then lay out something of a negative plenary power doctrine, just like there is a negative Commerce Clause power. I agree with Ambassador Harper that that Laura really establishes or shifts a way of thinking about the federal government's power over tribes, which I actually think is correct, looking at pre-constitutional history. And there are a lot of uncomfortable concepts in the history of Indian law, but they're also foundational. And one is the doctrine of discovery, which from looking at it from a perspective of imperialism, we think of as being quite offensive today, but it was also something that gave the crown plenary responsibility for dealing with tribes. And the Articles of Confederation picked up on that by saying that the Congress has the sole and exclusive power of regulating the trade and managing all affairs with the Indians. So it's not just trade in the sense of commerce that we think about it today, it's managing all affairs with Indians. But it had another clause saying that doesn't affect the legislative power of a state. And those two things seemed and probably were in operation in conflict. And one of the goals of the Constitutional Convention was to get rid of the second part of that, which is giving states power over Indians, but they did nothing to undo the first, which was to manage all affairs with Indians. Now, there are two parts of the Constitution that in particular speak to tribes. The Indian Commerce Clause, which mentions commerce with the Indian tribes as well as with foreign nations and among the states. And then also the Treaty Clause, while it does not specifically refer to Indian tribes, Congress both carried forward pre-existing treaties and entered into treaties with tribes. And I think there's sometimes a modern day temptation to say those are the only grants of authority in the Constitution, and every justification for a federal statute has to be crammed into one of those. But I think they actually have quite a different significance, which is they are manifestations of an underlying understanding that tribes were sovereigns. And in the Indian Commerce Clause, for example, the clause is addressing Congress's power with respect to commerce with sovereigns, foreign nations, states, among the states, and tribes. So it's not, I think, so much a grant of power in the sense that it's a power to deal with tribes that wouldn't exist otherwise. They were writing a clause that talked about sovereigns, and so they naturally included tribes. And the same thing about treaties. The court has said that Indian tribes were entities capable of entering into treaties. And usually one thinks of someone, an entity capable of entering into a treaty as a sovereign. Now, some tribes don't have treaties, but that doesn't mean they're not sovereigns. In the international sphere, the United States recognizes a number of nations in which, as sovereigns, and are subject to, or our relations with them are governed by general principles of international law, whether or not we have a treaty with the particular nation. So I think underlying that is an assumption not only that Congress has the power of managing all affairs with the Indians, but also that Indians are organized, if you will, as tribes, as nations, as sovereigns. And so the significance of that is not simply to look at either the specific Indian Commerce Clause or the Treaty Clause, or what lies behind it as a justification for present day laws, but also what lies behind that, what is unspoken when Congress has either acted or it has not acted. And before I get into that, one other point I wanted to make is that a number of terms have been used through the evolution of Indian law, the doctrine of discovery, as I mentioned, guardian-ward relationship, the discussion in Kagama, which one might think of as a guardian-ward approach, that Congress has to have the power because the national government did a lot of unfair, horrible things to Indians, and therefore the government has a responsibility to make up for that. And then today, the general trust responsibility. I don't think those are doctrinally or analytically different. I think they are an evolution of a different way, or of the same way of thinking about Congress's power and Congress's relationship to tribes. And the United States as a sovereign and a tribe as a sovereign have the power to reconceptualize their relationship over time. That is part of what a sovereign can do. What is my relationship with another sovereign? And although the names have changed, and therefore I think the conception of Congress's power and its relationship with tribes has changed, they all rest on the same underlying understanding that the national government, as the successor to the crown, has responsibility and power in Indian affairs. Now, the point I wanted to make about the negative plenary power is what significance should be attached to Congress's failure to act. And I think it's when looking at present day tribal sovereignty, I think a corollary of the fact that Congress has plenary power with respect to Indian tribes is that if Congress hasn't acted, the tribes retain whatever they had. In other words, it's not, I think there's a temptation sometimes to look at the power of Indian tribes in almost a common law sense, that the courts can develop what makes sense today for tribes, what powers tribes should have. But if you think of it in plenary power terms and go back to the founding, the tribes were sovereigns with presumptively all powers, except some that were inconsistent with a dependent status, such as entering into treaties with foreign nations and probably with states as well. But they had the full range of sovereignty. And so in deciding what the present day responsibility of a tribe is, I think it is necessary or an important focus to look at what statutes Congress has enacted to divest a tribe of sovereignty. And if you can't find something, then there probably has not been a divestment. And the Supreme Court has addressed this most directly in sovereign immunity. And I think the court often refers to the common law sovereign immunity, but they also do that with the United States and with states. It's common law in the sense, I guess, that it's not statutory or that it's not written in the Constitution except for the 11th Amendment. But it's not common law in the sense that courts can decide to impose it or not impose it. It's judge articulated, but sovereign immunity is an aspect of sovereignty. The United States has it, foreign nations have it from the founding all the way back to the Schooner Exchange. States have it, ratified by the 11th Amendment, and tribes have it. It's an aspect of sovereignty, not an aspect of Indian sovereignty. And so the court has repeated that it requires Congress to divest a tribe of sovereignty if the tribe doesn't waive it. But that's not a sovereign immunity specific thing. I believe it is, in fact, an aspect of sovereignty that comes with recognition of tribes as sovereigns. This is kind of an aside, but I think it's an important point to think about, is that when thinking about what the sovereign powers of a tribe are, it is useful as a touchstone to say, what are the powers of other tribes, or other sovereigns, and to claim the same degree of sovereignty, same attributes as other sovereigns have. And that's why I think, for example, that thinking about tribal sovereign immunity and when it applies and when it doesn't apply, it's a useful touchstone to use the familiar principles of state sovereign immunity and even federal sovereign immunity. So there's a way in which thinking of tribes as not distinct is, I think, both an accurate reflection of their sovereignty and useful for tribes. We've made similar arguments with respect to the personal immunity of tribal officials, rather than trying to urge the courts to sort of develop their own principles about when tribal officials are subject to suit, for example. Look at parallels in state official immunity or federal official immunity, and then how do they apply to Indian tribes? I think another situation where actually drawing parallels to other sovereigns is I think important and protective of tribes. But this point I'm making shows up elsewhere. If you look at Oliphant, where the court said tribes did not have criminal jurisdiction over non-Indians, they didn't just say that as a matter of judge-made common law, there were some touchstones on that. And an important one was that Congress had enacted the Non-Intercourse Act of 1834, which created federal crimes in Indian country for crimes affecting non-Indians. And Congress had sort of taken that under its own control. Now, it didn't say in so many words that divested the tribe. And this is an aspect of Indian law where courts, I think, are willing to, and properly so, I think, willing to read broader ramifications into acts of Congress than they might in other areas. But that is because they are acting against a background, often unspoken, of existing tribal sovereignty. And so the statute may not need to say everything it might otherwise have to say if it was acting in a vacuum. But I think a significant part of that there was nothing inherent in Indian tribes being divested of their power by the fact that Lara said that Congress could reinstate or lift the bar to the exercise of jurisdiction over non-member Indians of the tribe. And now Congress has done that with respect to non-Indians under VAWA. So the inherent sovereignty which may have been divested can be revested in the tribe by Congress. Another place where I think this is sometimes overlooked is in the Montana case and the Montana Doctrine, which has to do with the power of tribes over non-Indians on reservations. That has come to be viewed kind of in a common law way. You look at the exceptions that Montana articulated for when a tribe can exercise jurisdiction over non-Indians. But an important piece of Montana, although it's really spelled out a lot in a footnote, is that this flows from Congress's action in allotting or opening up Indian reservations to non-Indian residents. And what I think it's fair to say is that what would Congress, or what flows from that? What would Congress have expected to flow from the opening up of a reservation to non-Indians? And I think the assumption was the non-Indians would be governed by the state law and the Indians would be governed by tribal law, except since it's still a reservation, there's some things that Congress would have expected if it expected the reservations to continue for the tribes to have responsibility over. And so if you think about it as what flowed from Congress's decision to open up the reservation, then you have a touchstone for deciding when tribal powers should exist, including taking into account, as Judge Wood did, notions of extraterritoriality. If something happens on an Indian allotment, that's presumptively something the tribe should be able to regulate, even of non-Indians. If it's off, presumptively not. But maybe Congress would have expected some extraterritorial effect for tribal government because there was a tribal government with responsibility throughout the reservation, and it would have expected the tribe to have some power. And this is reflected in the Supreme Court's decision recently in the Cooley case, where the court said that tribal police could stop non-Indians, even though they couldn't be prosecuted, they could be stopped just as a matter of maintaining law and order, and the person who was stopped could be turned over to state officials. Well, Congress surely would not have expected that tribal police could not patrol a road through the reservation for the protection of tribal citizens, even though there were non-Indians on the reservation. So I think you could think of that as flowing from Congress's judgment. How does the allotment statute make sense? The ceding of a right-of-way for a highway makes sense within a reservation, thinking of it in statutory terms. We've made a similar argument with respect to tribal court jurisdiction over non-Indians. Unlike criminal jurisdiction, where there is, you had the 1834 Non-Intercourse Act under which Congress took that under its control, there's no comparable thing for civil jurisdiction. And in fact, the Public Law 280 presupposes that states don't have that jurisdiction. So would make sense in the structure of the statutory schemes we have for Congress to, for tribes to retain that power as, again, a negative implication or a negative plenary power way of looking at it that Congress hasn't acted. And I think all of this, and there are other manifestations of this, which I think tie into something Judge Wood was talking about, the canons of construction in favor of Indians. I think one way to think about that is that they map onto an idea that sovereignty is not, sovereignty or other protections of Indians are not divested unless it's clear, unless it would have been clear to the tribe in the treaty, for example. So the sovereign powers continue until expressly extinguished. That's true of treaties. Just think of McGirt, where Congress had all but eliminated the tribe in that case, leading up to Oklahoma's admission to statehood. In fact, it contemplated the tribe's termination, but extended it at the last minute, allotted the land, and I think Congress thought that the tribe and the reservation were going to be wiped out. But 100 years later, the Supreme Court said, no, Congress didn't actually accomplish that. And because there was a treaty promise in particular, the tribal sovereignty and the tribal reservation continued to exist. We see that as a proposition in whether a reservation continues to exist more generally. It presumptively exists until you find something that took it away. Again, a notion of negative plenary power. And it's also present in preemption of state law, where the court has given a broader compass to preemption there, because, again, I think the court has given broader compass because it understands that when Congress enacts a federal statute addressing Indian affairs, it is doing it with respect to a sovereign entity that is controlling its territory. So I think that there is a way in which there's that's a backdrop or a unifying theme that one can look at issues that come up in a variety of contexts with respect to Indian affairs. What are the consequences of Congress's plenary power, which means it's not for the courts to divest, it's not for the states to divest, or for the executive branch to divest. I also wanted to, a couple of other things I wanted to discuss. The Supreme Court's, talk about some Supreme Court decisions here that the court has had. I mean, down through history, the Supreme Court has been, I think, for the most part, protective of tribal interests. Just go back to the Marshall Trilogy, but down through the years, the court has taken a lot of Indian cases disproportionately to the number of people who are tribal members in the country. I think the court has seen a special responsibility for Indian tribes. And the Supreme Court's cases, to some extent, have tracked, at least in the time I've been doing this, tracked kind of the modern developments of Indian law, the kind of rebirth of tribal sovereignty notions, beginning with the Indian Reorganization Act, but after the termination era in more modern times. I think starting in the 80s, for example, the court first started with preemption cases. There were a series of preemption cases in which the court said the states have to stay out of this, recognizing, I think, in many cases, based on tribal sovereignty. But then the cases started moving toward tribal jurisdiction over non-Indians, and that is still a work in progress as the court is working it out. But cases like Williams versus Lee and National Farmers Union, Iowa Mutual were all, even though there are questions about the extent of jurisdiction, they were affirmations of tribal courts as being an essential part of the sovereignty that Congress has not divested. The court also is very protective of treaty rights. Again, we saw that strongly in the McGirt decision, but the Washington fishing vessel cases dealing with Northwest fishing rights, the Supreme Court has stood by those treaty rights. And then there are others, the Herrera case that I think Judge Wood mentioned, Cougar Den out of Washington State, the Milok case. So the court, when it sees a treaty, is inclined to uphold the treaty because the nation made a promise, or as Justice Black said in his dissent in Tuscarora, great nations like great men keep their word. And even now, the court has several Indian cases, and also the Brackeen case, which Ambassador Harper discussed. But they took a case, they invited our views, United States views, in a case involving the Isleta del Sur Pueblo in Texas as to whether it had powers to operate a casino, parallel at least to those of other tribes. It basically affected 2 small tribes in Texas. But the court granted review in it, I think partly because this was, for a lot of tribes, the ability to conduct gaming operations is critical to their economic well-being and expression of sovereignty. These tribes were treated differently than almost every other tribe in the country. And I think the court may well have had a sense of responsibility to address that particular tribe. Another case that the court just granted, a case called Dinespi, which has to do with double jeopardy clause as applied to a conviction of an Indian in a court of Indian offenses, which were courts established actually by regulations of the Interior, Department of the Interior, but principally to enforce tribal ordinances that have been approved by the Secretary for tribes that did not have their own court system, which was certainly true for many years. Most tribes now have developed them, but they were, and there's another discussion in the restatement about the executive branch's responsibility under 25 USC 2 and 9 to assist or implement or carry forward Indian affairs where, for example, the tribe did not have the infrastructure to do so. And so these courts were established to implement the tribe's sovereign power to establish law and order on the reservation. And those courts go way back, but it's sort of fascinating that the Supreme Court today is going to be thinking about that. And the Brackeen case involving the Indian Child Welfare Act, there are a number of challenges, as was mentioned. 10th Amendment challenges to the extent the state has to implement the provisions of ICWA in terms of the priorities for adoption or removal of a child, temporary foster care of a child. But again, it just occurred to me listening to this, if you think about international affairs, Congress, the federal government has entered into the Hague Convention on International Kidnapping, which provides that in the states must apply the standards of the International Convention, and Congress is implementing statute with respect to children who have been kidnapped or brought to the United States from another country. And yeah, there's an extraterritorial aspect to that, but Congress is protecting or is entering into the field of foreign relations and entering into agreements protecting children from other countries, from other nations. Well, you can think of ICWA as doing something of the same thing. It arises with respect to a proceeding off of a reservation, but at least the child's parent has to be a member of the tribe, a political classification that Congress has decided, I would say, I'm thinking off the top of my head anyway, by analogy to what Congress can do in the international sphere. And the last thing I wanted to mention with respect to the general trust responsibility and how that plays out in the executive branch, and particularly in the Department of Justice and the Solicitor General's office, we get involved in almost every Indian case that comes before the Supreme Court. And, there are times, obviously, when we in the tribe disagree. We were on the other side of McGirt because of longstanding understanding and practice of no federal jurisdiction in the area of the 5 tribes in eastern Oklahoma, because we were of the view, took the position that a whole bunch of statutes at the time of Oklahoma statehood had abolished the reservations, and it would have a substantial impact on law enforcement, as we've seen. So there are situations in which the United States will oppose a tribe. And this obviously comes up where, under the Tucker Act, for example, where we're sued, or the breach of trust responsibilities that Ambassador Harper was explaining. And I'm not going to get into those. There are some particulars of that I think at least I would not agree with. I should stress that everything I've said is my own view. I'm not talking on behalf of the United States government here. I'm just giving some thoughts. But for the most part, we see our responsibility informed by Indian Affairs, what the Department of the Interior or the Indian Health Service or other aspects of the government believe programmatically. But we have, over the years, been defenders of tribal sovereignty, of tribal government, protection of tribal interests against preemption. But I've come to think of that in the divestment model, the negative plenary power model that I was describing before. I haven't articulated it that way, but as I say, I've come more and more to the view that it is useful to invoke Congress's plenary power in that way, and not just as support for what Congress has affirmatively enacted. So with that, I think I'll stop. Thank you.
Thank you very much, Mr. Kneedler, and thank you to all 3 panelists for 3 really outstanding presentations. Before we go to the question and answer session, I'm going to announce the 3rd secret word for our online CLE participants, and the word is government. Okay, so now we'll open the floor up to questions.
So I have a question here. Thanks. Yeah, I've got a question that has a particular relevance to Wisconsin, and it involves the policy that BIA was following in the mid-1960s called termination, which turned out essentially to be a disaster, and the government had to back off on it. But my question is this: what would be the status of Indian sovereignty and Indian rights, Indian nations' rights, if termination had gone through? Thanks.
That can go to anybody. If any of the panelists want to dive in and answer.
I mean, I could start. I think it would be dependent. A lot of what Ed was saying is true. I mean, Congress has the authority under federal law to completely dissolve the polity of a tribe. At least that's what the law says. So it would really be highly dependent on the specificity, specifics of whatever the termination legislation does. For example, if there is a off-reservation hunting and fishing right, if you terminate the tribe, does that continue if the legislation does not specify that those treaty rights are terminated? Because usually you have to do it in unmistakably clear terms. So it would be dependent on that. But by and large, I mean, from my vantage point, it would just be it would have been a very challenging circumstance. And all tribes who have experienced termination have gone through years and years of litigation to reestablish the federal acknowledgement.
I may be misremembering, but didn't the Menominee have hunting and fishing rights even after termination, before they were restored? I think a similar issue came up with Klamath, but I can't really remember. But if Congress could eliminate a tribe, it could. There are gradations of things that it could do short of that. I think there may also be questions whether individual Indians, individual former tribal members might still be eligible for certain programs established for Indians. Normally, it's understood that there should be some tribal relation for a person to benefit from a program, but there could be programs for which that wouldn't be true. And of course, the tribe could continue to exist as something other than a federally recognized tribe, as its own organization, own membership. It would presumably lose governmental authority. Might be questions of whether the state could allow some exercise of governmental authority.
So we've got another question here from Dan.
My question is for Mr. Kneedler, and before my question, I want to thank you. The brief that you guys submitted in the Isleta del Sur Pueblo case, I think, was one of the strongest amicus briefs I've seen in a long, long time. Indian country appreciates your efforts there. I want to ask about what I perceived as a bit of a contradiction. I appreciate your position on what you called the negative plenary power, that tribes retain whatever powers are not expressly divested by Congress, and your explanation of Oliphant and in particular Montana, where you said that Congress seemed to have presumed that when it opened up Indian lands to non-Indian settlement, that non-Indians on those lands would be subject to state law. The contradiction I see, I see a couple of places I want to push back a little bit. One, I'm not sure why Congress's presumption should be favored over what the tribe presumed would happen with its lands once those lands would open up. And I understand that those cases evolved in a more purposivist era in statutory interpretation, but to say that the law is what Congress presumed is at odds with our more textualist direction in interpretation today. But it also seems contrary to the Indian canon that says, and the clear statement rules that Professor Fletcher was talking about earlier, that says that tribes deserve the benefit of the doubt there, and that if a tribe is not expressly divested, that it retains those powers. So how can Congress's presumption of what it did, rather than what it actually enacted, because it never expressly took tribal power over non-Indians on their land away, be the law, and how can that be consistent with your idea of negative plenary power?
Yeah, first, let me say two things. One, I sort of came up with the term negative plenary power as one way to look at a common thread running through a number of cases. I'm not proposing it as a doctrine, and I don't really want to be understood as saying that. It's just a way of explaining the role of the backdrop of tribal sovereignty in a number of different areas. And when I said presumption, I guess what I meant, it was probably a bad choice of words, is one should look at what Congress did in thinking about it in that way. It's not really Congress's subjective intent. It's what makes sense in what Congress has enacted here. Having an area that is occupied by both Indians and non-Indians, subject to separate governments. How does it make sense where the two, where citizens of two different sovereigns, shall we say, or governed by two different sovereigns? How does that make sense in a checkerboard situation? And so in that situation, there's, I think, some force to the idea that that federal and tribal law should govern the lands that are still in trust or restricted allotment and maybe in fee, and state law presumptively or ordinarily not. Now, I grant you there are some situations where the court insists upon an explicit statement rather than something less explicit. And some of that may have to do with the period in which these things occurred. The 1834 Non-Intercourse Act, where there was very little federal legislation in the area, and today where you have a pretty complex web of things. So I don't think the explicit part of it applies across the board, but I do think it is useful to ask whether the claim that a tribe has lost some power can be traced to something Congress has done. That was really the point that I was making. And Montana itself, as I said, does attach significance to the structure of the Allotment Act in analyzing the question.
So we have one more question. We're about 10 minutes over. So we kind of want to keep this short, if we can keep it to maybe under 2 or 3 minutes. Kyle, can you run the microphone over to the gentleman in the middle of the second to last row?
Thank you. Okay. My name's John. I'm a student here at UW-Madison.
Hold down the power button.
Yep, good time. Is it good? Are we good?
Really hold down. There should be a light that pops along the. I can review this one also. That one might have died.
Okay.
Technical error.
Thank you. Now are we good? Okay, great. My name's John. I'm a student at UW-Madison, and I didn't realize we were so over time, so I'll try and keep this brief. I was just curious. Well, first of all, thank you for coming out, and I appreciate all of you guys taking the time and effort to come and speak to us about these topics. I myself am part Ottawa Native American. I was just curious whether or not, because I'm completely unaware of these legal subjects, which is part of the reason why I'm here, so I can learn a little bit, whether or not the federal government or state government has any role in adjudicating disputes between different tribes. Because I know historically, Native American tribes have occupied overlapping territories and have frequently engaged in disputes of various kinds. I imagine most of the time relationships between tribes is collaborative, and so there aren't a lot of disputes. But I hypothesize that might sometimes occur. Does the federal government have any official role in helping resolve those issues? Thanks.
I think the federal government's ordinary role would be to use its good offices to try to bring the two tribes together, but they're both sovereigns. And in international affairs, if you have a dispute between sovereigns, generally the United States position is that doesn't belong in courts. That's something that the two sovereigns should work out between themselves. And it's not something I've looked at, but I would think that would ordinarily be the federal role. There are situations of disagreements between tribes where they share the same reservation and may have different views on how a particular issue ought to be dealt with. And I think Interior would try its best to, it's up to the two tribes. Maybe there would come a time when the federal government would have to do something, but in respecting the two tribes' sovereignty, it would ordinarily be up to them to work out. I don't know if others have a different view of that.
I would just add that there could be particular statutes that would govern, and what I'm thinking of is a case I saw out of Wisconsin, actually, where two different tribes wanted to establish a gaming establishment, and it made no sense to have them in the same areas. So there are, of course, elaborate procedures under the Indian Gaming Regulatory Act, and they applied there.
Yeah, as Judge Wood is alluding to, I would say that it really depends on the particular claims and circumstances. There are shared reservations like the Wind River Reservation, for example. And generally speaking, those are difficult circumstances because you're undermining both tribes' sovereignty at that point, because each has a veto of the other's policies. Well, not on every issue, but on a lot of issues. But I would also, I completely agree. It's sort of, is it gaming and therefore adjudicated under the Indian Gaming Regulatory Act? Is it a land dispute? And then what is the history there? It really depends on what the particular circumstances are and whether or not federal courts have jurisdiction in that instance. But I'd also agree with Ed that there's a large swath of these issues that I don't think there's necessarily an ability for federal court jurisdiction to adjudicate.
Well, I believe that brings us right up to our lunch break. And before we go, I need to announce the fourth and final secret word for online CLE participants, and the word is enforcement. I want to thank our three distinguished participants, Ambassador Harper, Judge Wood, and Mr. Kneedler, again for those excellent presentations. And I'll turn matters back over to Dylan Ochoa to say whatever he needs to about our upcoming schedule. Thank you so much for attending this excellent panel.